Arbitration has become an important way to resolve disputes in Malaysia, especially as more people and businesses look for faster, more private and also cost-effective options compared to going to court. Arbitration law in Malaysia has developed a lot since the old Arbitration Act 1952, which followed the UK's Arbitration Act 1950. Today, arbitration is not just for big commercial or construction cases. So in today's video, we will look at how arbitration has evolved and its current role in Malaysia. That will we be focusing on three key areas, which is consumer disputes, mandatory arbitration clauses in contracts, and also employee rights. They matter because they highlight how arbitration can affect regular people and not only just businesses.
Among other types of ADR, comparing to the rest, which is mediation, negotiation, conciliation, and so on, arbitration comes in handy as the decisions made by the arbitrators are always binding. And arbitrators, they are granted authority to issue awards, which also give the parties to the dispute fairness and finality in their claims. So, I would like to talk about the Malaysian position in terms of arbitration in consumer dispute. So, for arbitration, this process is bound by the Arbitration Act, and also in terms of consumer dispute, they are bound by Consumer Protection Act. Consumer Protection Act established a tribunal claim, Consumer Claims Tribunal, which also known as Tribunal Pengguna. And it is a process or another method for consumers, usually those with lower value dispute, to resolve their matter. Now I would like to talk about the downside of arbitration in consumer disputes. Okay, nowadays arbitration can be costly because it is now mimicking court procedure. Mimicking court procedure in this term, in this sentence, refer to as people that they treat arbitration as to replace court proceeding. So some of them, they will appoint lawyers and they will appoint counsels or advisors in order for them to execute the arbitration process. So this can defeat the original purpose of arbitration, because arbitration is usually will be an option because it costs lesser than court proceeding. And consumers, if they opt for arbitration, sometimes they will have inequality of bargaining power because they are bound by arbitration clause in contracts. Usually, businesses or companies, they will add mandatory arbitration clause in order to compel the other party to opt for arbitration process as a first step to resolve the dispute. So it can be seen in the case of Ajwa for food industries against Pacific Interlink, where this case, the court held that the arbitration clause is binding, which will restrict options among consumers because they are bound to opt for arbitration if there are any dispute. So apart from that, nowadays arbitration, if people opt for this process, they will have a restricted chance for appeal because the awards are final and the judicial review is also minimal, and therefore the consumers, they will be bound by unfavorable outcomes because they have limited to none option to appeal or to file for review, especially in the high courts, because high courts, in terms of arbitration, they have limited power to conduct appeal or review. Okay, apart from that, there are also language and procedural complexity. As we know, arbitration they also involve cross-border disputes, especially international between international organizations. So it would not favor those who have lesser English proficiency. Let's say in Malaysia, the arbitration process they apply English language. So to consumers who have lesser English proficiency or they could not transverse in English at all, they would have to spend extra money. They would have to spend more in order to hire a translator or advisor or any appropriate individuals in order to assist them to execute the process. So it, again, as I mentioned before, it defeats the sole purpose of arbitration, which is to reduce costs and to skip all the necessary long process which is found in the court litigation procedure. In Malaysia, arbitration, in our opinion, should not replace statutory protection under the Consumer Protection Act. However, it must and it can be used to serve as a complementary mechanism. So that is all from me, and I'll pass the floor to the next presenter. Thank you for watching.
Arbitration has become the preferred method for resolving contract dispute because it's natural, efficient and private compared to litigations. This is reflected in contract through arbitration clause, which require party to resolve current or future dispute through arbitration. Arbitration clause can be mandatory or non-mandatory. Mandatory clause compel parties to arbitrate and prevent court actions, often seen in consumers, employment and commercial contract. In Malaysia, key doctrines like separability, where the arbitration agreement is independent of the main contract, and competence doctrine, which allow tribunals to decide their own jurisdictions under Section 18. This ensure clauses remain enforceable even if the contract is challenged. Malaysian court interpret arbitrations agreements broadly, following principles like those in Fiona Trust and Privalov, assuming party intended all dispute arising from their relationships to go to the single arbitral forum. This approach promotes certainty, efficiency and cost saving, preventing dispute from being split across multiple courts or tribunals. Enforceability of arbitration clauses in Malaysia is mainly governed by Arbitration Act 2005, supported by Contract Act 1950 and judicial precedents. For a clause to be enforceable, it must exist clearly and be in writing, which can include contract, letter, email, or even statement of claim or defense acknowledging the arbitration agreement. Clarity is key. The clause should define the scope of dispute, parties involved, seat of arbitration, procedural rules, and where possible, reference governing law or institutional rules such as ICC or AIEC. Under Section 10, Malaysian court must stay court proceeding if there is a valid arbitration agreement, unless it's null or impossible to perform. Court adopt a pro-arbitration stand but prevent abuse. For example, in the case of Kebabangan Petroleums and Mikuni, refusal to comply with arbitrations can waive the right. In Line Clear and MISAT, the court allowed a stay with conditions to protect the other party. Therefore, Malaysia enforced arbitration clause but still ensuring fairness, making arbitration is a practical alternative to litigation. Malaysian court consistently uphold arbitration agreement, emphasize that once a valid clause exists, a stay of court proceedings is generally mandatory under Section 10 of Arbitration Act 2005. In the case of Ajwa, the Federal Court confirmed that arbitration agreements no need formal signature, reference in email, letter, or standard terms are sufficient. Further case like Press Metal Sarawak and Etika Takaful reaffirm the competence principles, allow arbitrator to decide their own jurisdictions. Court grant a stay once a valid arbitration agreement exists, protecting party autonomy while preventing abuse. Recent decisions such as Lion Pacific and Pistache and Seti Awan and SPNB clarify hybrid or optional clauses, confirming that even permissive language doesn't make arbitration unenforceable. Malaysian law now strongly favor arbitration, aligned with international standards like UNCITRAL, modern law, and the New York Conventions, while ensuring procedural fairness. In short, Malaysian courts are pro-arbitrations, balancing efficiency, party autonomy, and fairness in dispute resolution. Globally, the UNCITRAL model law provides a flexible framework for international arbitration, define arbitration agreement, and guide court to refer dispute to arbitrations. Complementing this, the New York Convention ensures that foreign arbitral award and agreements are recognized and enforceable across border. Malaysia has aligned closely with this standard through its Arbitration Act 2005, updated in 2011 and 2018. Malaysian court adopt a pro-arbitration approach, enforcing agreement even when clauses are permissive. Doctrine like separability and competence allow tribunal to determine their own jurisdictions, while enforcement grounds such as finality or public policy mirror international norms. In short, Malaysian arbitration framework is efficient, reliable, and internationally recognized, providing a practical alternative to litigations and ensure consistency with global practice in dispute resolutions.
A core issue in employment arbitration is the significant difference in bargaining power between employers and employees. Usually, there are arbitration clauses in the employment agreement, which is made without meaningful negotiation between the employers and employees, which makes the employees may not fully grasp their implications or may not know what is the clauses is all about. So employees might unknowingly give up their right to seek remedies through the industrial court, which is specifically designed to protect workers. So there are two statutes. Moving on to the legal provisions and case law. So in Malaysia, we have two laws for labour, which is Industrial Relations Act 1967 and also Employment Act 1965, which are designed to safeguard the employees. In Section 20, Industrial Relations Act 1967, it allows employees to challenge unfair dismissal. So the industrial court can order remedies like reinstatement or compensation, and remedies that are not always available through arbitration. Moving on to the Arbitration Act, under Section 9, it stated that the validity and enforceability of written arbitration agreements. But the concern in employment issue is this section can be problematic in an employment context where consent may not be truly voluntary by the employees. Moving on to Section 10 Arbitration Act 2005, which stated court have the power to stay legal proceeding if a valid arbitration agreement exists, potentially diverting cases away from the industrial court. Moving on to the case law, in the case of Colgate-Palmolive against Yap Kok Fong. So in this case, the court demonstrates the judiciary role in protecting employees' rights. The court awarded compensation for unfair dismissal, affirming that statutory protections cannot be easily undermined by contractual terms. So this highlights the importance of the court in upholding the public policy. So, does arbitration protect employees or undermine their rights? So, arbitration has its own advantages, which is quicker resolution of disputes, keep sensitive matters confidential, and arbitrators may have specialized knowledge. But there are also disadvantages which may bypass the specific protections and remedies that offered by the industrial court. And private proceeding does not mean serious issues like harassment or discrimination doesn't and it will limit the legal proceeding. And also limited resource because arbitrator awards are generally final and difficult to appeal. So in conclusion, arbitration can be useful for specific contractual issues such as bonus dispute. However, for fundamental employee rights like protection against unfair dismissal, the statutory framework and the industrial court remain the primary and most effective forums. Arbitration should supplement and not replace these crucial legal protections that was offered to the employees. Thank you.
Created using Powtoon.